Florida Live starts now.
Well, good afternoon to you and welcome into Florida Live. I'm Garrett Weimer and thanks for joining us on this Monday afternoon live on Fox Local, Fox13News.com, Fox35Orlando.com, and also on YouTube. Hope you had a good weekend and we appreciate you joining us here on this Monday. Coming up later in the hour, we are going to look back at the weekend when it comes to the theme parks and some noteworthy debuts over the weekend. I'll give you a live look at Epic Universe. You see the Stardust Racers going now. That still doesn't open for another few weeks, May 22nd. That's going to be here before you know it. But again, some noteworthy debuts at already open theme parks that we're going to talk about with Darren White coming up a little bit later. At 2:30, State Attorney Monique Worrell, who is the prosecutor for Orange County and Osceola County, she's scheduled to have a news conference responding to what we heard from Attorney General James Uthmeier earlier today. He held a news conference in Orlando offering additional prosecutors for her office and also a warning about policies that she has put in place, in fact, and just recently announced. We will talk more about that. We will also bring you that news conference live when it begins at around 2:30. But we begin today with a Florida roundup here and a couple of stories that we are continuing to follow up on today from over the weekend, including what we know about a drowning off Lake Worth Beach. This was a teenager who was killed and two others who were seriously injured over the weekend when they were stuck in a rip current at Lake Worth Beach on Saturday. We know lifeguards and first responders were able to pull those victims from the ocean, give them CPR. All three, we're told, were taken to the hospital. A 17-year-old boy was pronounced dead. A 12-year-old and another 17-year-old boy was conscious and alert and stable, thankfully going to be okay, but a scary situation there. And when it comes to rip currents, certainly something that you have to be aware of this time of year. Here's a live look at Daytona Beach in Volusia County. When it comes to rip currents, if you're stuck in one, officials say, of course, don't try to get to shore. You swim parallel to the shore until you escape that rip current. And the main thing in officials and beach safety will tell you and have told us many times here on Florida Live and on Fox 35 News Plus, and that is don't panic. But again, a scary situation and tragic details that we have learned from the Lake Worth Beach area down near Port St. Lucie and Palm Beach, I should say as well. We are also continuing to track another story along the Atlantic coast, and that is a search that has been going on for missing boaters after a capsized boat reported over the weekend. The Coast Guard says they rescued 4 people Sunday, 29 miles off St. Lucie Inlet. This is a picture of the boat that the Coast Guard tweeted. The boat capsized Friday. 1 person was found dead. 4 people rescued, but the search has been ongoing for 5 more missing people. The Coast Guard tells us they have handed off that search, still waiting for trying to learn some more details about the status of this. These are some photos from the Martin County Fire Rescue that we know responded and took the rescued victims to the hospital. But again, another kind of developing situation along the Atlantic coast as the search continues for some missing boaters after a boat capsized. Give you a look. This was just moments ago inside a courtroom in Volusia County where Jean Massine, his attorney, was in court. They were discussing some pretty procedural things, scheduling, those kinds of things. But we learned from court documents in the past week that Massine or plans to use an insanity defense when he stands trial. Massine is accused of stabbing a Daytona Beach couple to death back in 2022. Brenda and Terry Altman were their names. They died during Bike Week of 2022. Now, court documents, again, they say that Jean Massine does plan to use the insanity defense. He had been previously deemed competent to stand trial. So we wanted to learn more about what an insanity defense might look like in this case and how it is used. So we spoke earlier on Fox 35 News Plus with Jose Rivas, a criminal defense attorney not connected to this case, but who kind of walked us through the different elements of insanity defenses.
The court has already determined that he's competent to stand trial. So we're past that stage. I know there were some issues whether he was competent or incompetent. Now, what the defense needs to prove, and it has to be through clear and convincing evidence, is that at the time of the crime, he had some kind of what we call mental infirmity, disease, or defect. And because of that condition, the defendant, in that case, did not know what he was doing, he or she was doing, or the consequences. But if he knew also that the defendant did not know what he was doing was wrong. So in other words, we have what we call a psychotic break. And this is all about what we call a battle of the experts. But the psychotic break, so to speak, they have to sell it to the jury. And they have to determine whether when this break, he did not know the consequences of what he was doing or did not know that what he was doing was wrong.
And so that's interesting that you mentioned the competency. So it is kind of different because I think sometimes we think of when you hear pleading insanity or using an insanity defense that there may be something where they would not be particularly competent to stand trial. But what you're saying is those are separate, basically separate determinations and very separate sets of things that have to be proven.
Correct. The insanity defense is in what we call an affirmative defense. That the defendant or the defense has the burden of proof. It's on the defense to prove the elements. In this case, being that he did not know the consequence. Now, once he does that, then the state must prove that he's has proper sanity. Again, everybody, according to the law, everybody is presumed to be sane. So the defense is going to try to prove that it's trying to achieve what we call a not guilty by insanity. And then at that point, the burden shifts to the state, and they're going to bring experts. That's why we call it the classic battle of the experts.
And is there controversy over this? This is something that some states don't allow, as I understand it, or what? It's very rarely used according to statistics in criminal cases.
My understanding in Florida, about 1% of the cases it's used. But there are a lot of beliefs in regards to the defense. It's a hard sell to the jury. But again, it's battle of the experts. At the end of the day, it's going to be a lot of psychiatric evaluations. The defense is going to bring a lot of experts. It's going to be contradicted by the state. And at the end of the day, it's the jury that's going to have to make that determination. And there's also this thematic, thing that, this insanity defense is kind of a loophole for criminals to get away with crime. Mental health illness it's true, it happens. So there's certainly, that's why the law allows for it, but it's not an easy sell to the jury.
What makes it difficult for the jury to buy that? What's the challenge for you as a defense attorney trying to sell the jury on an insanity defense?
Well, you got to realize that just because they were insane or they determined that at the time, the jury needs to determine that at the time of the crime, that this defendant was, had this mental illness. So he could be at trial and they can see this defendant acting, communicating with his attorney. And, that's obviously going to affect them. It's going to say, well, he looks fine now, but they have to, jump the bridge to be able to determine whether he was had proper mental capabilities at the time of the crime. Remember, in order to do this defense, the defendant must admit or is acknowledging that he did commit the crime. So we already have that, on the state side, he admitted to doing the crime. Now it becomes what we call, battle of the experts, trying to prove to the jury that he was not in his right state of mind at the time of the crime.
Because of that initial step, like you said, basically having to admit that they did commit this act, does that make an insanity defense a bit of a risk in some ways?
It is, because the jury, again, and the funny part is here, the jury is going to know, exactly what, how the crime occurred, and you have to, although he's admitting to the crime, so to speak, the state's still going to prove on how the crime occurred, just to show the intent, just to show that he was in his proper state of mind. Juries, they're not doctors. They're not able to, understand mental health. But again, that is the defense job, to bring in some experts who can put it down in black and white, in very legal and very easy terms for the jury to be able to understand. But again, there's this systematic that thinking that just because you're you're found not guilty by intent doesn't mean you get to go home either. So that's also another scenario where we're going to have to address with the jury as well.
And so, what if that were to happen? Obviously, still a little bit away from a trial in this particular case, and that potentially happening. But if that were to happen, what happens if an insanity defense is used and the jury rules in their favor?
Right. If that's the case, he could be sent off to a mental health institution. And statistics show that actually people spend longer time in mental health institutions after being found not guilty by insanity than had they been sentenced to a regular prison sentence. So it's not like he gets to go home, and the jury's going to be made aware of that as well, too.
So certainly a case that we are keeping a close eye on as it moves forward. We're going to take a break here on Florida Live. When we come back, we're going to check in with Fox 13 for today's Tampa Connection. So don't go anywhere. We'll be back in 2 minutes here on Fox Local and on YouTube. Welcome back into Florida Live. I'm Garrett Weimer, and thanks for joining us on this Monday afternoon, live on Fox Local and on YouTube. It is time now for our Tampa Connection, and we bring in Fox 13 news anchor Linda Hurtado. And Linda, we appreciate you joining us today. I know we are starting, though, with a tragic story out of your area.
Yeah, it's really sad, Garrett. It's not the first time I've reported this type of story where a child with autism drowns. It really was a very sad discovery in Pinellas County, where the divers found the body of a 3-year-old boy in a pond after he had been reported missing. The sheriff's office tells us that Kyrie Larry left his family's apartment in Palm Harbor on Sunday afternoon. Deputies also told us that the boy's parents, they're hearing impaired, and they didn't immediately notice that the boy was gone. Investigators watched video from a nearby doorbell camera, which appeared to show the boy near a pond. That's when the divers came in, and then they found Kyrie's body in the water later that evening. And we understand that he was nonverbal and autistic. And again, that comes from the sheriff's office.
A lot of bodies of water, there's a lot of pools. I think this area is usually near the top in drownings, and I wish I had a better answer for it. It's just accidents happen. This appears to be a tragic accident. It's just, it's a nice Sunday afternoon, and the folks are watching TV like a lot of people are on a Sunday afternoon, and unfortunately he wandered out of the door and ended up in the pond. So I wish I had an answer to it. I just would remind people to be hyper vigilant when they have little ones.
So according to the Autism Society of Florida, drowning is the #1 cause of death among children with autism. It's because they tend to wander off, and they also appear to have a natural attraction to water. The Autism Society recommends early swim lessons to help prevent this tragedy, and the organization provides resources for parents and swim instructors. And really, our heart goes out to the family today. It's just tragic all the way around.
Yeah, it really is. And
Here's another. Go ahead,
Linda, we've had a few of those stories, similar circumstances in just the past few months here in our area as well, and it never gets any easier to hear about. And it's just a tough situation.
Yeah, and in a case with children with autism, I don't know that just getting them swim lessons is going to help or is the answer. So it's really just a difficult thing all the way around.
Yeah.
This next story kind of just makes me shake my head. I just think there's more questions that need to be answered, but it's a teen murdering a teen, and it's caught on camera. A 14-year-old charged with murder in St. Pete after police say he shot a 13-year-old while that victim was recording. So police tell us that Marcus Carr and Jaden Hill were sitting in a car late Saturday night when this shooting happened, and Hill was using a phone to record Carr, according to police, and then Carr opened fire. There's a lot of whys, motive. A lot of questions still need to be answered about this. Hill was rushed to the hospital where he later died, and Carr is now facing a second-degree murder charge. As for where the gun came from, police are still working to figure that out. 2 families affected tragically this afternoon. So another sad story coming from our area.
Yeah, one of those things you're going to be feeling the impacts of those forever. So
here's another interesting one. This one's taking place on the University of South Florida campus. They are among 3 public universities in Florida asking for federal assistance to deputize campus police officers to help with immigration enforcement. So that move comes weeks after USF was named as one of 60 schools across the country under investigation for possible anti-Semitism. So it also comes nearly a year after 10 people were arrested on USF's Tampa campus when a pro-Palestinian rally got out of hand and officers used tear gas to disperse that crowd. Fox 13 spoke with Florida immigration attorney Renata Castro, who says a lot has changed surrounding immigration, with President Trump putting a big focus on the issue, along with Florida lawmakers passing tough new laws in February. Castro also says the latest move by USF, along with the University of Florida and Florida Atlantic University, could be a sign of things to come. Let's listen in.
USF, it's not surprising that they took this position, and I have a feeling that a lot more schools will take the same position throughout Tampa and really throughout the United States because they rely on federal funding to survive.
So local law enforcement can be deputized for immigration enforcement through what is known as the 287G program, which allows ICE to partner with state and local agencies. So it's the same program that Governor Ron DeSantis has cited when deputizing state agencies such as like the Florida Highway Patrol and Florida Fish and Wildlife. Jail in all 67 counties across the state has also signed written agreements, with ICE since February, so the program seems to be spreading across our state.
Yeah, one of those things too. It's interesting to hear these conversations when these things come up in these board meetings and council meetings, commission meetings, because it seems like the interpretation of the state law is that these agencies really don't have any option, and so it's just we're starting to see more and more of these agreements signed now. That number continuing to grow and in all kinds of different agencies, including, as you pointed out today, universities. So Linda Hurtado, Fox 13.
We'll see how it affects the universities. Yeah, thanks, Gary.
Yeah, Linda Hurtado, we appreciate you joining us for today's Tampa Connection. We'll be right back. Welcome back into Florida Live. I'm Garrett Weimer, and thanks for joining us on this Monday afternoon, live on Fox Local and on YouTube. Strong words of warning from the state attorney general against one of the state attorneys today. Attorney General James Uthmeier saying that State Attorney Monique Worrell's policies, or at least her new policies announced, are not acceptable, he says, and, quote, "we are going to be watching." This is in response to Worrell's policy of not accepting new non-arrest cases. This is something that she said her office has had to put in place because of a backlog of 13,000 non-arrest cases. Now, the Attorney General says he's sending a team of prosecutors from the AG's office to help the 9th Judicial Circuit State Attorney's Office with that backlog. At this news conference, I'm going to play a portion of that for you here in just a minute. We also heard from Orange County Sheriff John Mina, who says that her office turned down 90 of their non-arrest cases last week alone. I want to play for you a little bit. We'll hear from James Uthmeier, we'll hear from John Mina, and also from statewide prosecutor Nick Cox.
We're here to offer help. I think most of you are aware of what's gone on the last couple of years. You had a state attorney here who decided that she was going to carry out policies where she would not prosecute certain cases. Unfortunately, that violates our Constitution. State attorneys, they take an oath to uphold and defend the Constitution, and they do not get a veto over certain laws. That is not appropriate for this branch of government. State attorneys, they enforce and carry out the law, and if our legislature and our governor have executed heightened criminal penalties, a state attorney does not have the ability to say, I'm not going to do that. So I think everybody's aware the governor suspended the state attorney here. Supreme Court, the judicial system upheld that and sent a message. You take an oath, you have a job to do, and we're going to make sure you do that job. Well, the state attorney's back, and already we have some new policies being pushed out where she's saying there are certain types of cases she's not going to take. Just last week alone, she turned down 90 cases from the sheriff's office here. That's not acceptable, and we're going to be watching. Now, in this policy, she says that she doesn't have the resources, and that's why a lot of these non-prosecutions are going to take place. We'll hear this morning, we're here to help. We're going to tell her the words that no Soros prosecutor wants to hear. We're from the AG's office, and we're here to give you help. So the cavalry's here. We've got a tiger team of prosecutors that we're going to be sending to help out. We hope she will take that help. We want to get rid of that backlog, those thousands of cases, and we want to make sure that dangerous people are put behind bars. We want to see bad guys go away. The people of Orlando, they don't deserve to be in an unsafe situation, and unfortunately in the past that has happened. Part of why the governor suspended, or there were numerous cases where you had serious felons that were let go very quickly. You've got a very aggressive felony case, they're let back on the street, and weeks later, murders take place. People are losing their lives because of non-prosecution policies. That cannot happen. We owe it to the people of Orlando to make sure that we are enforcing rule of law and that we are backing up our law enforcement. Our law enforcement put their lives on the line every single day and night to ensure that bad people go away. So what happens when what message do you send when all of a sudden you let somebody go after they've committed a serious offense, or you decide not to prosecute a serious offense? What message does that send to our law enforcement who put their neck out every single day? So we're not going to let that happen. We're here to help. We're watching, and we're going to make sure that we are doing everything we can to give the resources and make sure that we're prosecuting these cases. So I'm excited to be joined here this morning. We've got Orange County Sheriff John Mina. We've got the Florida statewide prosecutor, Nick Cox, who's kind of in his final lap with our office, and we're going to miss him, but appreciate everything he's done for the state. We have several chiefs with us, Chief Grisham from Belle Island, Chief DeShriver from Edgewood, Chief Manuel from Maitland, Chief Graham from Winter Garden, and Chief Metzger from UCF. We want to help these guys. We want to enforce rule of law, and we're going to send the cavalry down here to make sure that we're putting bad dudes away. So thank you. I'm going to turn it over now to Sheriff John Mina.
Thank you, Attorney General, and we will all want to thank you for this additional assistance here in Orange County. I think by providing these attorneys to this circuit, this will really help us clear that backlog of cases. I also want to thank the State Attorney Worrell for reaching out and asking for help. I know that's not an easy thing to do, but this is the right thing for Orange County and Osceola County and the Ninth Circuit here. We need to clear this backlog. We need to start working together to accept these cases, some very serious, and this is all about protecting the victims. All right, and as Sheriff of Orange County, I want to make sure that our residents and our victims know that we are fighting for them, and I want to make sure that no victim is ever forgotten. Again, big thanks to the Attorney General and his staff for helping out here in Orange County so that no victims are forgotten. Thanks.
I'll call up our statewide prosecutor, Nick Cox.
Good morning. I am very, very proud, General, to be here. Very, very proud to be here with these prosecutors. These are 4 of the prosecutors that we're going to be sending over to help the Ninth Circuit State Attorney get through their, what's reported to be a 13,000 case backlog. This is something that we're very proud to do, very happy to do. You know, when you have another prosecutor who's struggling and cases aren't being prosecuted, cases aren't even being reviewed for prosecution, it's time to worry, especially when there's 13,000 of them. And so we are very, very happy to be doing this. By the way, this isn't anything new for the Office of Statewide Prosecution. We have done this in the past for other state attorneys' offices. In fact, we did it here several years ago when the matter came up where Governor Scott removed State Attorney Ayala, former State Attorney Ayala, on the death penalty cases. And when those were assigned to the Fifth Circuit State Attorney, Brad King, we actually reached out to him and said, do you need a little help? Because you just picked up 23 death penalty cases, and we were assigned about 7 or 8 of them. So this is nothing new for us. We've done the same thing down in Key West. When they were facing some problems down there, it wasn't anything like this. They reached out to us and said, would you please come help us? We're having a problem having enough lawyers down here to prosecute cases. So for about 3.5 months, we went down there every day with 3 or 4 people. I went down and spent about 5 weeks there myself, handling everything from misdemeanors to capital murder cases. You know, the lawyers at statewide prosecution, we've been doing this a while. We generally have lawyers, we hire people that have been prosecuting for multiple years, and so they know what they're doing, they know how to do their job, and this is just an example of the folks who are going to be helping to do this. And so we look forward to working with the state attorney's office to try to clear this backlog, because as the sheriff said, if we don't get this done, it's dangerous. It's a public safety issue. And so we're glad to do anything we can to help Orlando avoid the public safety issue. And like the General said, put the bad guys away. Thank you, General.
So we've got great prosecutors across the state, great state attorneys, and everybody, you know, should share the same mission, which is making Florida the safest state in the country to raise a family. And if people need help, they should raise their hand and ask. I'll say, look, the life of a prosecutor is a tough one. They're not the highest paid positions, and the hours are not a cakewalk. You're working around the clock, and you're doing it because you're a public servant. And the people of Florida, you know, they don't want excuses. They want you to get the job done, and that's our duty, and that's why we're here today.
Here's a live look inside the state attorney's office in the 9th Judicial Circuit, where we are expecting State Attorney Monique Worrell any minute now to speak and respond to the offer of the prosecutors from the Attorney General's office, and also the words of warning from not just Attorney General James Uthmeier, but also from Governor Ron DeSantis, who spoke about this situation earlier today. He was asked about it at a news conference in Kissimmee. He said that Worrell's conduct could end up on his desk again because he previously suspended her from office one time before and said that something like this, he knows the Attorney General is watching closely, and so is he.
With respect to Monique Worrell, as you recall, I suspended her from office because she was not enforcing the laws as they are written on the book. She had her own agenda, and that was putting the people at Central Florida at risk. I think what happened was she was able to delay this and never went in front of the Florida Senate where I think they would have found her guilty and removed her permanently. And so she was able to kind of manipulate that. Obviously, it's a very Democrat area, so when you run as a Dem here, you have an advantage. But I will say this. You have a responsibility to faithfully execute the laws of the state of Florida. You do not have the ability to pick and choose which laws you're going to enforce. You don't have the ability or the authority to let the inmates run the asylum. So I know the Attorney General is keeping a close eye on what she's doing. That could end up on my desk if there's proof that somebody is neglecting their duties or satisfying one of the other provisions of the Florida Constitution. Then obviously I could act again.
So certainly something to monitor. We're going to take a break here on on Florida Live while we wait for Monique Worrell's news conference to begin. So we are going to step aside for 2 minutes, but we'll be right back. So keep it here on Fox Local and on YouTube. Here's a live look inside the state attorney's office for Orange and Osceola counties, where we are anticipating a news conference any minute now to respond to the Attorney General, James Uthmeier, and what he said today, talking about offering her prosecutors, additional prosecutors, to help with the backlog of cases that she says she has with when it comes to non-arrest cases. So we will bring that to you live when it begins. In the meantime, Governor Ron DeSantis was in Kissimmee earlier today. He was talking about completion in just a couple of weeks now of the I-4 congestion relief lanes in the Kissimmee area. So from Polk County to Osceola County, that stretch there where some help with the traffic, is certainly needed. If you've traveled between Tampa and Orlando, you know that. And he said this project is going to be done 8 months ahead of schedule, announcing that opening date of those congestion relief lanes at that news conference just a little bit ago.
Now, I think most people who are in Central Florida know we've got a lot of public roads, 12,000 miles of state highway system, and that alone are public roads, 332.4 million daily vehicle miles traveled each and every day in the state of Florida. We have a big, it's efficient, but it's a big Department of Transportation budget, and you have to manage very many billions of dollars. I mean, we're $15-16 billion for that, and it's important. And right now there's 700 active construction projects across the state. Anywhere you look, there's something happening in the state of Florida. Now, those aren't all road projects. There's a lot of commercial projects. I mean, I was just down in the Sarasota area, Longboat Key. I attended a charity event, and that got hit by 2 hurricanes last year, and you really wouldn't know it. I mean, these people are out there, massive tourism, massive cranes, a lot of stuff happening. And that's really been true all across the country, or all across the state of Florida. Our infrastructure is typically rated in the top 5 in terms of quality of roadways. If you look at like New York, they have really bad roads. You know, they charge you exorbitant amount of tolls, and yet the roads, you get sick just being on them because they're so bouncy. In fact, they want to do congestion pricing in New York City. I know there's a big battle over that, but I mean, like, people pay a huge amount of money every day just to go into work, and yet where does that money go? It doesn't go very far. Here in Florida, we take pride in the quality of the roads. Now, we're always looking to do better, and there's things we're looking to improve on. We also were able to do 2 years in a row, and which was big, I think, in Central Florida. We did the toll relief, 50% reduction in tolls for our commuters on a monthly basis. You know, that saved people over 2 years hundreds of dollars in a difficult priced economy with all the inflation that we've seen over the years. And so I was proud to lead that effort to help deliver the toll relief for folks. Now, the Moving Florida Forward has been really, really well received. We initially started with $4 billion out of the surplus. We've now delivered a total of $7 billion. So this is everything we were already doing, having a strong transportation budget, all that. We continue to do that. This is on top of that. So there are projects in the queue that are now being brought to fruition that likely wouldn't have broke ground until the middle of next decade. We have at least 20 major interstate and roadway projects that have been expedited through Moving Florida Forward. Addition of regular and express lanes on I-275 in Pinellas County, reduction in traffic delays up to 85%, and helps with hurricane evacuation routes. A redesign of Golden Glades interchange on I-95 in Miami to enhance connectivity between major road corridors in the region. Very difficult area in the state of Florida for traffic. And this is going to be helpful. Very difficult because it's all built out. Reconstruction of the Fruitville interchange on I-75 in Sarasota County to a diverging diamond design. We've showed that previously. You know, these guys study all this stuff and they can tell you what's faster or what's not. So this diverging diamond is going to increase volume capacity by 40,000 vehicles, and it will reduce the number of conflict points between merging vehicles. They also have done studies. You know, every hurricane season, if we do have a storm and people evacuate, we'll always get asked, are you going to do contraflow and shut down one way and make it all one way? And we always say no, because this has been studied and it just doesn't work. Partially because you still need to get people coming into the hurricane zone for first responders, for supplies, emergency. There's a whole bunch of stuff that needs to happen, but they've looked at it and it doesn't work. So the things that they're doing in terms of these designs, these are things that have been vetted. Widening US 98 in Bay County near Panama City Beach. And you guys go up to the Panhandle, you know, I mean, it's amazing how that's boomed, particularly in the last 5 or 6 years, but the traffic can be really, really bad. So that's going to be helpful. We're also going to do the realignment of US 301 from County Road 470 to Florida's Turnpike near the Villages in Sumter County. That's going to increase mobility and reduce delays by up to 94% during peak hours. And last month, I was in Ocala when I announced the addition of new auxiliary lanes to I-75, over 31 miles from State Road 44 in Wildwood to State Road 326 in Ocala. And that is going to be done 10 to 15 years ahead of schedule. And any of you who've gone up 75 north from here, you know how bad that can be. So this is a very important project that we're able to do. So our total investment in infrastructure over the next 5 years is going to approach $70 billion in projects. And most of the focus is reducing congestion and improving the safety of Floridians, which brings us to today's announcement. Last June, we made a promise to deliver congestion relief lanes through one of the busiest sections of I-4 by the end of this year. Not only are we delivering on our promise, but we are going to beat our own deadline. I can announce that the completion of the two new, here's the congestion relief lane. So you look at some of those areas, World Drive all the way into Polk County, Champions Gate, Celebration area. This needs it. I mean, this is a really big deal. So we are pleased to announce that these lanes will run in both directions between US 27 in Polk County and World Drive in Osceola County. They will be open beginning of the week of April 28th, which is 8 months ahead of the schedule that we had laid out.
Well, I want to go ahead and get you inside the state attorney's office as this news conference gets underway. You see Monique Worrell there and officials beginning to talk about the backlog of non-arrest cases in the prosecutor's office. So let's go ahead and listen in.
So I'd like to, without further ado, introduce our state attorney, Monique Worrell.
Thank you. Please hold your applause. Good afternoon, everyone. I thank you all for joining me on what is obviously very much anticipated address on the current situation dealing with the backlog of non-arrest cases here in the Ninth Judicial Circuit. I want to start by letting you all know that about 9:30 this morning I received a call from statewide prosecutor Nick Cox, and we have arranged a meeting for tomorrow where we will discuss how we can implement the assistance that has been offered by the Attorney General. I look forward to meeting with him to discuss how we'll be working together to clear the more than 13,000 non-arrest cases that have backlogged in our circuit. I also look forward to sitting down with local law enforcement to discuss additional collaboration in this policy, and I want you all to know that those discussions have been in the works ever since the release of this non-arrest policy a few weeks ago. As I said before, collaboration is critical to ensure the public safety of our community and to removing violent offenders from the streets. Public safety should always take precedence above politics. And while we know that this circuit receives more scrutiny and different levels of scrutiny because of politics, we have an obligation to work together to solve the problems of this community. So I look forward to collaboration with all relevant stakeholders to put public safety above politics. And putting public safety above politics means being honest about the facts that this problem has been allowed to grow and fester for decades. And what I am doing right now, here today, and with the implementation of this policy, is putting an end to temporary solutions that haven't fixed the problem. And I believe that by working together, we can permanently fix this backlog of non-arrest cases. So, unfortunately, what the Attorney General has offered is another temporary fix to the situation. The statewide prosecutor's office has a long history of providing support to local jurisdictions and providing additional prosecutors. And of course, having them come to our office is welcomed. We can certainly utilize the help so that we can work as quickly as possible to get through the backlog of cases. And after we've done so, I will continue to advocate for additional permanent resources, because once that temporary support is no longer here, we can expect that backlog to creep up again. As I stated in my letter to the Attorney General, this reality has far more to do with flat funding while our population has grown exponentially. And an increase in population necessarily results in an increase of cases coming through our system. But the resources to review these cases just haven't kept pace despite our repeated requests for additional funding. I think I said when I rolled out this policy that year after year we go to Tallahassee to lobby for additional funding, additional spaces for prosecutors in our office, and year after year those requests are denied. We need a holistic approach, which is why in my letter to the Attorney General, I requested 13 additional prosecutors and support staff to process this backlog. and to make sure that we don't just create another backlog. It's vitally important that additional support is provided for the long term, because when those resources aren't present for even a short period of time, the case backlog can quickly escalate. During my first administration, or what we've affectionately referred to as 1.0, I put in place staff to work solely on reviewing those non-arrest cases. And under the interim administration with the appointed state attorney, the staff was either released or reassigned. And at the end of 2024, there were 12,118 non-arrest cases that had come in. So I just want to reiterate for all of those who have heard differently and for those who are saying differently, this is not a Monique Worrell problem. This, in fact, is a problem that dates back to at least 2013, where, as WFTV reported at that time, Jeff Ashton was discussing non-arrest cases that he inherited when he took office. And his solution to many of those cases was to drop those cases. And we have worked diligently to ensure that we don't have to drop cases because we don't have the manpower, but rather that we get the manpower that's needed to adequately service the people of the Ninth Judicial Circuit. I know it's a good political talking point to try to make this about me, and some continue to try to do so, but this community deserves better than that. They deserve more than politics. They deserve results, and that's exactly what I will continue to advocate for. Now, I have some numbers that I want to review with you, and I'm also going to have one of my investigators, my Deputy Chief Investigator, Dave Amon, come up and talk to you about some of the non-arrest cases that we've received so that you can have some more concrete examples. It's something that I didn't do before, but I want you to receive these concrete examples so that you can have an idea of, when I say non-arrest cases, what I'm talking about, because it's very important for the public to understand that. All right, so on the screen behind me, you'll see, and I'm highlighting the last several administrations so that you can see what the numbers were under each administration, so that you can have an idea of how this is relative and also how it's not simply isolated to my administration. So in 2012, that was the last year of Lawson Lamar's administration. He received 13,459 non-arrest cases. I'll move to the side so that I'm not blocking your shot. All right, and in 2016, under the last year of Jeff Ashton's administration, there were 13,110 non-arrest cases. In 2020, under the last year of Ms. Ayala's administration, there were 12,660 non-arrest cases. But what's important to note with that is that it was also the COVID year, so all of the numbers of cases filed that year were down. In 2022, the last full year of my first administration, the number was 13,512 non-arrest cases. And in 2024, the last year of the appointed state attorney's administration, it was 13,459. So you'll see that the number of non-arrest cases that's received is relatively the same, no matter who's sitting in the seat. And that's really important, again, because when people try to make this a Monique issue, the numbers say something different. So I'm going to preempt your question, which may be, well, it wasn't a problem for any of these other state attorneys. Why is it a problem for you? Well, the answer is it was a problem for each of these state attorneys, and each state attorney has employed different tactics that they use to try to address the problem. All of those policies that they implemented were only temporary fixes to the problem. What I'm advocating now is for a permanent fix to this problem that several other administrations have tried to find but have not yet been able to do so. I want to talk to you a little bit about where the non-arrest cases come from, the majority of non-arrest cases come from. Orange County Sheriff's Office and the Orlando Police Department are our two major law enforcement agencies in this community. And in 2023, from Orlando Police Department, we received 1,475 non-arrest cases, in comparison to the Orange County Sheriff's Office, from which we received 4,915 non-arrest cases. In 2024, the number from Orlando Police Department was 1,712, in comparison to the 5,789 received from the Orange County Sheriff's Office. In 2025, and we're just in April, we received 488 from Orlando Police Department and 1,614 from the Sheriff's Office. So as you can see, the majority of non-arrest cases that we receive come from the Orange County Sheriff's Office. And I'll tell you that that is about policy. So if you look at the Orange County Sheriff's Office policies with when to send cases to the state attorney's office, you will see that in that policy, under number 4, file charges with the state attorney's office, specifically in C, it says that if the incident involves a non-view misdemeanor and the charge is not a warrantless exception, the deputy shall means you must, file the case with the state attorney's office, not arrest or try to obtain an arrest warrant. So in the Orange County Sheriff's policy manual, they direct their deputies to file cases instead of seeking an arrest warrant or making an arrest. So this in and of itself can account for why you see that there's a dramatic difference between the number of cases that we receive for the Sheriff's Office as opposed to the number of cases that we receive from the Orlando Police Department. Now, similarly, if we look over at the policy that comes out of the Orlando arrest here today is that the judges are not signing for misdemeanor warrants. Well, Orlando Police Department has put that in their policy. It says that the Orange County judges will not sign a misdemeanor-only arrest warrant unless there is evidence that the defendant is unlikely to appear for a summons. If submitting a misdemeanor-only warrant, officers shall fully document in the warrant affidavit all evidence demonstrating a defendant is unlikely to appear on a summons. The evidence may include all efforts to locate the defendant, facts showing the defendant's a flight risk, a record of failing to appear for court, and any transient or unknown resident status. Here, the Orlando Police Department has outlined in their policy what you need to do in order to get a valid arrest warrant. And this is why we're seeing a lower number from the Orlando Police Department than we're seeing from the Orange County Sheriff's Office. There's policies and procedures that have to be followed, and these policies come from the law. So when they're saying that we can't get warrants, well, they can get warrants, but they have to provide the information that is required by the statute in order to receive those warrants. Since the start of our policy on April 1st, of the 225 cases that we received from the Orange County Sheriff's Office, of the 255 total non-arrest cases that we received, we returned 225 of those to the Orange County Sheriff's Office for non-compliance with the policy. Out of the 225 non-arrest cases returned for non-compliance, 85 of those cases were domestic violence cases. Now, I want to take a moment to talk about the importance of domestic violence as it relates to this whole non-arrest conversation. When a victim reaches out to law enforcement because they've been involved in a domestic violence situation, this is a cry for help. They are reaching out to law enforcement because they have been harmed in some way, and they are asking for help. When that case is sent over to the state attorney's office to sit on a shelf with 13,000 other cases, that's not giving them help. And you can say, well, why don't you do something about it? Why do you not let it sit on a case with 13,000 other cases? And I'm telling you, the reason we don't do that is because we don't have the resources. We want to help the victims and survivors in our community to get the help that they deserve. That when they call on law enforcement to get help when they are a victim of domestic violence, that their abuser will either be arrested or that a warrant will be put out for their arrest, and that they won't let their case languish on a shelf with thousands of other cases with an already underfunded and overburdened state attorney's office, that we will get them the immediate help that they need to keep them safe. To that end, I want you to know that
Garrett Weimer here. You're watching Florida Live. Want to let you know, if you are watching on Fox Local Tampa, we're going to wrap up here in just a couple of minutes, and you'll have your regular programming at 3. If you're watching on Fox Local Orlando or on YouTube, we will continue with this news conference from the State Attorney Monique Worrell.
By the time we're able to process through that cases, you have people who aren't around anymore. You have evidence in a case that's been diminished. And we can't bring justice to those victims who have reached out to our office for help. That number could increase exponentially if arrests were made on the scene, if the proper evidence was gathered at the time. And our domestic violence unit has met repeatedly with law enforcement in an attempt to partner to build the best and strongest domestic violence cases from their inception, telling them what's the evidence that they need to gather so that we can successfully prosecute this case. My chief of domestic violence has done trainings with law enforcement and is continuing to do training specifically this year with the theme of strangulation and how law enforcement can recognize strangulation, domestic battery when they go to a scene so that we can help save victims. So we take this very seriously, and anything that you're hearing that tells you otherwise is just simply false. In 2021, we filed on 9% of these domestic violence cases, and I want you to know that that's coming from 2010, where only 3.6% of those cases were filed on. So again, if someone's telling you that this is a Monique Worrell issue, the numbers don't lie. People lie. Numbers do not. So we are filing on more than 3 times more cases than previous administrations have filed on. But yet still, this number from 3,226, where we only were able to file on 308, is not good for our community. That's not keeping our community safe. So I'm going to have Dave come up. He's going to talk to you a little bit from a law enforcement perspective. It's important for you to know that I have law enforcement officers right here in this building, but I don't have 2,000 like the agencies have. I have 13. And those 13 law enforcement officers help us with serving subpoenas so that we can get our witnesses to come to court and testify so that we can make our best efforts to bring justice to the victims of the 9th Judicial Circuit. But he's going to talk to you because he's been diving into some of the non-arrest cases that we receive and why it's so important that we work collaboratively with law enforcement to reduce the number of cases that we have to lay eyes on when they really can make determinations on their own. So Dave, would you come up and talk to that?
Good afternoon again. As you see, I'm going to kind of change my hat. I'm the de facto PIO here, and we're hoping to get a full-time person on board. But I'm also one of the investigators here. As State Attorney Worrell said, we have 13 sworn police officer investigators here, 2 of which are standing on this stage, and we're tasked with covering our entire circuit, which is Orange and Osceola County. So what we had done when we discovered this backlog, we tried to step in, and under both administrations recently, we've assigned 1 full-time investigator to take a look into those 13,000 cases. Now, you may ask what type of cases. I've had that question from you folks are in the 13,000. Well, if I had a crystal ball, I could look into them. But what I can tell you today is some of the cases that we have seen. Our office takes domestic violence very seriously. Although it is a misdemeanor, we can see that we cannot tolerate violence, and many times domestic violence can lead to more serious cases, such as homicide. We see that recently. So we've kind of done a focus on domestic violence, and one of the things we've seen is we are really excited about working with our law enforcement partners because, as we've stated from the podium before, a law enforcement officer needs what is called probable cause to make an arrest or go and obtain an arrest warrant. And usually when they make an arrest, that's when that case comes to us. Now, once it's passed to us, we have a much, much higher burden of proof, and that's called proof beyond a reasonable doubt, which is something that we would have to show in order to obtain a conviction. Well, what we're seeing in a few of these cases, and I have some examples that I'll read to you, are that the law enforcement officers have been sending cases over here where they haven't even jumped the hurdle of probable cause yet. As a matter of fact, some of the cases that we've seen statements written in affidavits such as unable to substantiate probable cause. Well, if you send us a case that you're unable to substantiate probable cause, the likelihood of us being able to jump that bigger hurdle and say we can prove that case beyond a reasonable doubt is really, really going to be difficult. So suspect was not arrested due to lack of evidence available to establish probable cause. Throughout the investigation, probable cause could not be established. So those cases are going to prove problematic. Again, I said I don't have a crystal ball to see what the 13,000 are, but from our past review, we've noticed that there is a sizable amount of these cases where if we could just ask law enforcement, instead of sending those cases to us where they haven't met their burden of probable cause, that they work with their detectives and maybe, try to bolster their probable cause. We do have on-call prosecutors, multiple prosecutors we send out every week that are on call to where local law enforcement can give them a ring and they can talk about that. We even have specifically a domestic violence prosecutor on call all the time. So we would ask that before you send them to our office and they sit in a stack and we already believe that they have no probable cause, that either you work a little harder to get probable cause, or sometimes there's just not going to be probable cause, and there's nothing magically that the state attorney's going to be able to do to take that no probable cause. There's nothing we're going to be able to do to make probable cause. So what an effort, and I'm a career law enforcement officer, worked all around the circuit here, so I know a lot of these folks. What we're trying to do is say, hey, could we just, if you don't have probable cause, could we not send them over here if you don't have probable cause? Because all that does is make that cases that we have to go to and sometimes say, yeah, you don't have probable cause. So we're obviously not going to file on that. So we want to kind of, instead of a floodgate, we want to see if we can work with them to narrow our focus and send only the cases that have probable cause. And if you don't, give us a call. We'll see if we can help you get probable cause. Contact your legal advisor. So as far as our investigations unit, that's what we're going to be working with law enforcement to see if we can just narrow that. The fewer cases we get, the more attention we can give to those cases. Thank you, Ms. State Attorney.
The probable cause discussion is really important. I was looking through social media after my last press conference, and I saw that someone commented that I want law enforcement to do the state attorney's job. And what that showed me was that people don't really understand the separation between law enforcement and the state attorney and what our different roles are. So it's really important to understand that the role of law enforcement is to make sure that there's probable cause. Probable cause means that it is probable that a crime was committed, one, and that the person who they are making the complaint against probably committed the crime, right? It's very basic. If law enforcement can't establish that, there's no way that we are going to be able to establish that. And the reason is because they're on the scene. They're interviewing the witnesses. They're talking to the victim. If they can't establish probable cause at the scene of the event, there's nothing that we are going to be able to do to build probable cause once the case gets here. So it's really important for the public to understand what the role is of the state attorney and what the role is of law enforcement and how those roles are different, but how one builds upon the other. So when we get the case, our job is to now take law enforcement's probable cause and take it to beyond a reasonable doubt. And sometimes, through no fault of law enforcement, we can't make that happen. Sometimes we get probable cause and we can't turn probable cause into beyond a reasonable doubt because there's just too many things missing and there's a gap, right? And we work with them at that point to try to build it. But as Dave just explained to you, if the case comes in and it doesn't even have probable cause, there's nothing that we can do to make it beyond a reasonable doubt. There are a few things that I want to clarify, and there's some misconceptions that I'd like to address. If you remember from 1.0, I did a whole press conference about facts matter, because facts do matter. And when you are in a position such as mine as state attorney and some of the other elected and appointed officials who've made comments with regards to this policy, the truth is important. I want to clarify my policy because there's been some mischaracterization as this policy as being a blanket policy or inconsistent with policies that have been implemented by other state attorneys to deal with non-arrest in their own circuits. I think it's important for you to understand each state attorney is elected, for the most part, to deal with the matters that impact their circuit. So when I make a policy decision, I'm not looking for validation from any other state attorney for what works best in the Ninth Circuit, because the people of the Ninth Circuit, 414,000 of them, elected me to make decisions that are best for the Ninth Circuit. But out of an abundance of caution, what I do is I look around to other state attorneys to see if they're facing similar problems, if they've implemented similar policies, so that I can have a basis upon which to build for what works best for the Ninth Circuit. This was no exception. My executive director reached out to all of the other circuits and asked, do you have this problem? If so, how have you dealt with it? And to it, we received a policy that has now been widely circulated from the Fifth Circuit, where they also clearly had a non-arrest problem that caused them to develop a non-arrest case policy. As my policy states, non-arrest cases that will be accepted are homicides, sex crimes, human trafficking, child abuse, drug trafficking offenses, traffic homicides, animal cruelty, economic crime, wildlife commission cases, and civil citations. It's not a blanket policy because I just named for you, I don't know, probably 9 exceptions that allow us to review cases that are non-arrests. And in all other cases where we have said we won't accept them, my policy clearly has a provision where law enforcement can reach out to our on-call attorney. Now, we don't have just one on-call attorney. We have an on-call attorney for every single division in this office. We have an on-call attorney for domestic violence. We have an on-call attorney for homicide. We have an on-call attorney for sex crimes. So wherever there is a need for discussion, law enforcement can always reach out and we can have discussion, because our goal is not to regulate what law enforcement can and can't do. It is only to make sure that we are providing public safety measures for the people of the Ninth Judicial Circuit. My office will never refuse to prosecute a case where probable cause has been properly established. The only thing that this policy set out to do is so that law enforcement can help us build the strongest cases possible, so that when they come in the door, we're taking it down the road to beyond a reasonable doubt.
Garrett Weimer here. You're watching on Florida Live, this news conference. It appears as if there was some sort of medical emergency, something going on there. So we will continue to monitor this situation. If the news conference starts back up, then we will get you back to it. But just to recap a little bit here, as far as what the state attorney Monique Worrell was saying, talking about this policy that has gotten a lot of attention from the state attorney general. From the governor as well, that she announced, let's see, I believe she said the first, which would have been just about 2 weeks ago, saying that her office was not going to accept many non-arrest cases anymore. You heard her just talking about some of the reason for that. She did outline again today a number of exceptions to that, saying this is not a blanket policy. This is not a refusal of cases that have probable cause, but she said this is a policy that she believes helps build stronger cases. So she talked about receiving a call today, 9:30 this morning, from Nick Cox, the statewide prosecutor, and she said they are going to meet to discuss how to implement the assistance of the prosecutors from the state level that Attorney General James Uthmeier was talking about earlier today. She said this is a problem that has festered for decades, and a number of previous attorneys, previous temporary solutions have not helped fix. And what she said is that the Attorney General's offer is a temporary fix, not a permanent solution, and that they hope, her goal, she said, is to continue to advocate for additional permanent resources in her office, because this is a problem that she says has been exacerbated as the funding for her office remained flat, even as the population of Orange and Osceola counties continued to grow. She also went through some numbers there that showed pretty consistent number of non-arrest cases coming into the office, going back to 2012. So the previous administrations, 1, 2, 3 previous administrations before, and then her first term, and then the term of Andrew Bain, who replaced her after she was suspended. All of those numbers pretty close to the same. The one significant outlier would have been 2020, which was a year that obviously things were a little bit strange with the COVID pandemic there. So her point being relatively the same number of non-arrest cases received, regardless of who is in office there. So and talking about ways to combat this. So she does plan to accept the help from the Attorney General's office, it sounds like. But again, meeting with the statewide prosecutor, they're going to have a talk about how to implement the help from those statewide, from the prosecutors coming from the state level. So we are continuing to follow this. I'm going to go ahead and wrap up here. It does not appear that news conference is
Florida Live starts now.
Well, good afternoon to you and welcome into Florida Live. I'm Garrett Weimer, and thanks for joining us on this Monday afternoon, live on Fox Local, Fox13News.com, Fox35Orlando.com, and also on YouTube. Hope you had a good weekend, and we appreciate you joining us here on this Monday. Coming up later in the hour, we are going to look back at the weekend when it comes to the theme parks and some noteworthy debuts over the weekend. I'll give you a live look at Epic Universe. You see the Stardust Racers going now. That still doesn't open for another few weeks, May 22nd. That's going to be here before you know it. But again, some noteworthy debuts at already open theme parks that we're going to talk about with Darren White coming up a little bit later. At 2:30, State Attorney Monique Worrell, who is the prosecutor for Orange County and Osceola County, she's scheduled to have a news conference responding to what we heard from Attorney General James Uthmeier earlier today. He held a news conference in Orlando offering additional prosecutors for her office.